Hi, my name is Robert Chelle with Chelle Law, and I'm an attorney that assists nurse practitioners with employment contract and independent contractor agreement issues. Today I'm going to talk about common nurse practitioner contract mistakes. So what are some things that I see maybe after the fact, if someone didn't come to me before they signed the contract and now that they're in the contract and perhaps want to leave, what are some, main areas of concern? First, compensation. Now, I think the majority of nurse practitioners are paid a straight base salary. So pretty simple. You work whatever is expected and you get paid a certain amount and that's it. If you come into hybrid models of maybe a certain amount of guarantee base and then maybe some net collections, bonuses, or if you work in a hospital or healthcare network, perhaps some RVU expectations, you want to make sure that you understand what the percentages are when you're paid the bonuses. Many times the contracts won't say that. If you leave, are you going to get paid any of the bonuses that you earned? So let me give you an example. Let's say somebody has a 35% net collections model where it's just whatever the practice receives from you, you get 35% of that. Well, many contracts have language that says as soon as the contract terminates, you get no more compensation. And so, a normal kind of accounts receivable cycle for an insurance claim, somewhere between 30 to 45 days. I mean, depends upon the state, whether it's private or state funded or federal, but let's just say it's 30 days cycle. Well, if you're working those last 30 days and your comp ends when the date that terminates, they received none of that money from the last month. You just worked for free for an entire month. So you want language that makes absolutely certain that you're going to receive all collections received after your date of termination. I mean, it'll save you thousands and thousands of dollars, or not save, you'll earn thousands and thousands of dollars that you should have received. All right, next would be malpractice, or maybe some unclear malpractice language. You have to identify what type of policy you have. Is it occurrence? Is it claims made? And then if it is claims made, who pays for tail insurance? That should be absolutely spelled out in the contract. There should be no ambiguity about that. Non-compete issues. This is huge for an NP for the following reason. Any non-compete contains three components. You have scope, so what you can't do. The time restriction, how long you can't do it for, and then the geographic restriction, where you can't do it. So for a nurse practitioner, you want to limit the scope to whatever you're doing for the practice that you're with. So for instance, if you're working in an orthopedic practice, it needs to say you can't practice as a nurse practitioner in orthopedics within, for 1 year and 10 miles of the clinic. It should not say you can't practice as a nurse practitioner, or I've even seen some contracts that say you can't practice nursing at all. So even if you wanted to go back and do some RN work, PRN or something like that, you'd be unable to do that. So, if you're working as a hospitalist, then it needs to say you can't work as a hospitalist, within 10 miles. It just gives you options and flexibility to continue working in the area where you live. And it makes no sense that an employer can justify that, let's say you're working in a nephrology clinic, that you can't work as, just doing primary care if you're an FNP or something like that. There's no justification for stopping you from working if it has, there's no competition between the practices. So that's a huge red flag, and that needs to be changed in any nurse practitioner contract. Scope issues, what you can and can't do. Now, if you're in a state where you have to have a supervisor or collaborator, you're going to have to sign two agreements. One will be the employment agreement, and then the second, you'll have some kind of, it's called different in each state, a collaboration agreement, supervision agreement that's filed with the Board of Nursing, whatever state you're in. So you want to make sure that you're not being limited by your employer for things that you are legally allowed to do. Now, maybe they don't want you doing those things, but I find many places who may be starting to use NPs that have never used them before don't understand how to utilize them correctly, and so you want to, and this is really a conversation that you should have before you sign anything, of what are my expectations, what are the things that I can do, that I'm allowed to do, and so everybody's on the same page before you start. All right, well, those are just some common nurse practitioner contract mistakes. If you have any questions about an employment agreement or independent contractor agreement, feel free to contact my law firm at the information listed below in the description. And I appreciate you watching the video. All right, take care.